beloved Prime Creator, who gave us life, also gave us a job to do, if we choose it. And we do. Imagine a pristine glass of water, glistening with light and life energy, offering its essence to fortify, providing essential minerals to nourish any dryness and to lubricate our cells with its intelligence. Now imagine the pure, beautiful essence of any body of water sullied with chemicals of man's making, contaminants from the waste of manufacturing spoiled with chemicals, and pharmaceuticals consumed and recycled with our waste, even chemical components and debris mixed with air and rain from above, saturating the beautiful soil and its microbes now struggling. This is the scene of putrefaction and death to the God-given gift of life to its most microscopic minuscule. Using the water as a metaphor, we are here to symbolically cleanse the putrefaction of our governance to purification, as best we can to purge evil and reclaim our rightful place as jura summa imperii, thus reclaiming our inherent, unalienable rights, God-given rights. Let it be so, and so it is.
Hello. This is a notice of intent across multiple intertwined issues. The intention is to require a jure, original jurisdiction, Article 7, Article 3, one Supreme Court claiming original jurisdiction, in Amendment 7, a jure civilian common law court of record on Oregon. So let me unpack that a little bit. Original jurisdiction is when the Constitution and the laws are correct without any fraud or de facto added. That's when we were actually legitimate, a constitutional republic. That changed. Article 7, all caps Article 7, Roman numeral 7, is from the Oregon Constitution, and that determines how the judiciary is going to act. The judiciary in original jurisdiction, like it came back from Washington, D.C., when it was still Washington, D.C., without the ink on it, incorporated, was still government, 1859. And then a jure common law court of record, Amendment 7. Well, Article 3 in the original Constitution that they wrote up for us is still there, and it is still legitimate. It's even in their de facto Constitution. And Article 3 is the court where a man or woman can find remedy against the state. If you go into any other court, you cannot find remedy. The other courts are not designed to give you remedy. So why go there? You go there because that's how you were trained. And it's not correct. It's part of the lie. So that court, Article 7, Oregon Constitution, the original judiciary, how it's supposed to be, not how the fraud is. Article 3, that designs and decided and issued how that court where a man or a woman can find remedy is set up. And then Amendment 7 from the Bill of Rights, because they had to make a bit of a change to protect me and you in suits in common law where the value exceeds $20. We have to have a jury, and we have to have a court, not a judge. All that stuff counts. He who can be deceived, that's who you are, and they will deceive you. So we unpack that a little bit. Okay, sheriffs, How can you not enforce what you know to be true? The sheriffs will have to answer that. They've been doing it for quite a while. We inform them, and they acquiesce to what is true. They don't seem to abide by the law. They abide by color of law. Play pretend. That has to stop. As there is no published or known testimony against or any rebuttal to our Article 1, Section 1 social compact. Right there, Article 1, Section 1. This is how you take it back and fix it. So we are. None that we have approached will receive us in caveat to will and probate in open court. I looked that stuff up. They're required by their own laws, rules, regulations, and boy, the older you get, the more words don't come. And when you need them, they're not there. You need a whole paragraph to say one word that you can't remember. Oregon revised statutes. When one fails to defend themselves on the field or in open court, they lose. That's just how it is in all law forms. And they don't. Secretary of State, 89 legislators, Kate Brown, Tina Kotek. There's lots of them. And they all acquiesce and they default. They cannot defend themselves, so they stay quiet. They acquiesce and they default. They lie, cheat, and steal, and they're caught. And they want to continue to lie, cheat, and steal. Not going to work. So how does one disassociate themselves from the fraud and false efforts, oaths and bonds of previous de facto iterations? Well, the first thing you do is self-correct. And when you self-correct, you eliminate all of that. Not hard, it's all written down. But it's not legal, it's lawful. Legal is what the bar is doing. And what the bar is doing is illegitimate and de facto. Has to be corrected. I was deceived until I was 75. Everything that is a lie must be corrected. Honor counts and is Jural common law. He who can be deceived, let him, is an inferior venue, jurisdiction and law form practiced by the Oregon State Bar members of the Article 7 amended 1910 de facto. If you honor that, you honor evil. The areas of interest. Due to the death of my wife, I find myself confronted with situations that will require a: 1, probate court, not a judge, a court with all the proper credentials, and an Amendment 7 jury. The court must be lawful, thus including Article 3, that special court where a man or woman can find remedy. No other court. And in compliance with SEC Jarcasi 603 US 109. That's where they tell them. The Fifth and SCOTUS agree. You have to have an Amendment 7. Amendment 7 is very important and covers several things. So you can't just pick and choose. I want to have this little piece out of 7 and none of the rest. Now you get all of 7. The court must implement ex parte Milligan. We've already done that one. To the best of my knowledge, the only one on Oregon. 2, the mortgage. There's a mortgage on this house. We did that mortgage in 2021 when the interest rates were quite low. And it appears that mortgage may not be legitimate. I did not have to participate in that until Aida died. And now I have to participate. That was all her responsibility. Now it falls on me, and I'm going to do it. I do not acquiesce to any infringements upon my unalienable rights. So that's the mortgage. And the next one is the HELOC. There's a HELOC on the property that was not recorded. The lender provided a HELOC, a home equity line of credit, that is supposed to be registered with the county, and it was not registered. If you don't register the loan as a home equity line of credit, then you're not keeping the contract and you fail. And then there's the automobile. The automobile was leased by A&R Enterprises, Inc., the corporation, because the tax situation is better if a corporation leases the car, leases the automobile. However, after the lease was over, then the choice has to be, do you lease another one or do you keep this and buy it? Well, the choice was made to keep it and buy it. But it was easier and better to buy it in her name and make it her car on paper. And that was a financial decision. Then she dies. And the car reverts back to the corporation. It's a debt. It's not an asset. Therefore, the bank does not have the choice on putting that into probate. Assets go into probate. However, they have legal counsel, a bar attorney, tell them that they cannot accept payment on the car to pay it off. And I offered them payment on the car 3 times to one of their executives. My daughter was witness to it. On the 3rd time, he went and got his boss, and she came over and she listened to it 3 times. And she went and talked to their attorney, and their attorney said, no, never mind. Don't worry about it. So in common law, when I offer to pay the debt 3 times and you decline the payment, the debt is paid. And we're in common law. So that has to be taken care of. And that's number 3, the HELOC. Number 4, the car, done. This is all located at my home in Beaverton. The 2 lenders of the 3 issues above, I will be filing for quiet title on the mortgage, the property, and the automobile. If you do not support your claim, you lose. Oregon is a common law state, and I am a man on the land and soil jurisdiction of Oregon. That's the jurisdiction where people are. Persons and corporations and businesses and entities in commerce deal in the other jurisdiction. I will not be deceived. I am not deceived. And I have a right to unfettered counsel. That's right in the Constitution also. And on Oregon, they changed the Constitution. They broke their oath, and they require bar attorneys to be counsel in all courts. Wrong. Not going to work. We have unalienable rights guaranteed by our constitutions. And we have an Article 3, Article 7, Amendment 7, Civilian Common Law Court of Record on Oregon. And if Oregon can provide that court, I don't think they can even provide Oregon. The state of Oregon is a bogus entity, a subdivision of the United States of Washington District of Columbia, Inc., that outfit. So I recuse myself from my court clerk obligations in this matter. That will be addressed in my claim of cognizance from our court. There are two jurisdictions. There is a de facto jurisdiction since 1910 that is illegal and illegitimate. And there is a jure jurisdiction that has been available on Oregon since November 2022. So that court is available. And I need that court. So our court sends the state of Oregon's judiciary, whomever, one of three or four, our document saying we have jurisdiction and the reasons we have jurisdiction. And we do not deny your jurisdiction. We just require you to provide supporting evidence that you have that jurisdiction. Now, that's not say, see the sign on the window or look at my business card. None of that. We know what law is. We know what evidence is. We have dictionaries to define that. It's not what the judge says. That's in the dictionary. Judges do not judge the law. Courts judge the law. But the Bar Association twists that to the point where judges can judge the law. No, they can't. That's why they amended it. Courts judge the law, and juries decide the facts. So that will be addressed in my claim of cognizance. You're aware of that, and they are too. At the root of this is law, not color of law. And we know that is defined in Bouvier's Law Dictionary, 6th edition, 2-volume, 1856. Nothing else is legit unless it duplicates Bouvier. If it does, then it's legit. The AI, ChatGPT, useless. AI is not artificial intelligence. It is a program designed to give you the answers they want you to have to the questions you ask, not the truth. You can make them stumble and fall down and lie in 2-3 minutes. It's useless. And I read that attorneys now submit their paperwork to an AI, and the AI writes it back much better. But it's wrong. People have to do that, not machines, not algorithms. That's not how it's done. You don't vote by mail. You go to a poll and you vote, and it's counted there, not back at headquarters. We don't trust you people because you've proven to be liars, cheaters, and stealers. And we know it. And it's over. So, law consists of the United States of America's Constitution and Oregon's Constitution circa 1859, and 32 other constitutions of the several states, and any subsequent law amendments with the proper supporting evidence, such as statutes at large and treaties. I must do this myself. No one can do it for me, and I cannot do it alone. Now say that. It's true for all of us. You can't do it by yourself, but you have to do it. Nobody can do it for you. You can't hire it done. You can't hire an attorney to tell you what your mind is supposed to comprehend when you actually do the work and read and comprehend. And if you don't comprehend, study, get unfettered counsel. You have to do it. Nobody can do it for you. We can't do it alone. So, the single best indicator of my intelligence is how closely I agree with you. That's a fact. And the single indicator of your intelligence is how closely you agree with me. Now, we're all supposed to agree on the United States of America's Constitution, the legitimate one, the real one, the one you can look at and determine that it is original jurisdiction. That's 1859 or 1860. Since then, it's been color of law. Many of us have read all the documents. And you should read the 2 United States Marine Corps oaths. That requires honor. Say Smedley Butler and look it up. In 1776, it became the unanimous declaration of the 13 United States of America, and it's spelled and styled a specific way. It is not the bullshit trip they give you that they call the Declaration of Independence. There is not one of those. That's play pretend, color of law. Then they styled themselves the United States of America, the name of the Confederation and Perpetual Union that has articles in 1777. The last article is our Constitution, 1859. The Constitution, once it was made, adopted, and used, is changeable. It's designed that way. That was a problem with the Articles of Confederation. They made a constitutional Republican form of government, Article 4, Section 4, and they did the best they could do, and they failed right off the bat. And they said, we know it's not as good as it can be, but let's get this part done. When we get this part done, we can fix it. And they did. They got it done, and they fixed it. It's called the Bill of Rights. That was the fix. Anything else is play pretend. It's something other than a fix, a remedy. Then they made the 11th Amendment and the 12th Amendment and the 13th Amendment, called Anti-Titles of Nobility, 13 Tona. That was in effect from 1819 until 1863 or 64. Then they made it disappear. They gave us a new 13 from the federal. There is no federal. The federal is bogus. It came into being March 1861. So then the last constitution, the last lawful iteration is Oregon's. There's 33 states. All the rest are territories still. You can put lipstick on the pig, but it's still a pig. So then you have to think of this as returning to a constitutional Republican form of government. That's not democracy, and that's not Republican, as in the parties. Both of those are illegitimate, illegal, and also I'm firmly convinced, evil. You cannot fix evil and you cannot negotiate with it. Just can't. Those that think you can't are wrong. It has been martial law in some form since 1861, except on Oregon. We implemented ex parte Milligan and we did away with martial law, Labor Code, and FEMA. Now, how can that be? Only Oregon. It can't, but the other states haven't done the work. With full faith and credit, they are open to having our work, but they have to do their work on the other 32 states. Then not one sheriff on Oregon has their proper bona fides and credentials. How can that be? Well, as I said at the beginning of this thing, multiple intertwined issues. When you think of this, think of it as being all together in a string, like horseradish. You ever tried to get rid of horseradish? It's all in a string. Or pouring the spit from a spittoon. It's all in a string also. It's got to be gone. We have to return to Jural. You acquiesce and you do it without a rebuttal, and this becomes a fact every time you get it and let it go. And we have 8 years of facts stacked up. And this will be used as evidence in court. I follow this with my living testimony in the form of an affidavit of truth, and that's available on our website. And I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.